All right, here's my good brother, one of my best friends around, Ched Jennings, who's done a unbelievable job. And I want to tell you, this guy, he cares about what he's doing. He cares about those workers he's out here representing, just like we do. And he goes to bat for them constantly. Not only that, but he has guided me and our organization into working through the issues involving workers' compensation here that affects all the workers in Kentucky. Let me tell you, and the things that he's taught me about this system, and the fact that he helped set the damn thing up years ago. He's still at it every day. He's out there, and you all know he comes to your local union. He'll talk to your members. He'll try to make sure they get treated fairly in a system that really generally sucks. And I'll tell you what, he's out there with us every day, and I want to thank him. Come on up, Ched.
Thank you, Bill, for such a kind introduction. This is great again to be with you all and talk a little bit about workers' comp. But that reminds me, it wasn't just yesterday, for those of you a little bit older. I remember when Bill first came on, the labor leaders at that point in time telling me just how much I would like and end up liking Bill Londrigan. What he does, how he does things, his writing abilities, his statistics. It really has been a great relationship, Bill. I like to tell everybody, it really didn't take me long to figure out that Bill Londrigan knows, and many of you here today know this, workers' comp is one of the battlefields for organized labor collectively. It doesn't maybe affect, hopefully it doesn't affect the members, but you've got people who are going to get hurt next year, 5 years from now. It's important to understand just how important this system needs to be and how fair it is. Bill mentioned yes, I did help. I was probably instrumental in designing the administrative law judge. Not the law, necessarily, in terms of the benefits. The administrative law just system that we have today back in 1986. So I'm going back a few years with that. But let me also tell you that Bill was great and motivating. And he asked me every thought, he said, you've got your attorneys. We were working on cases together. And Bill, we would file in very, very important cases on behalf of the AFL-CIO, a brief, an amicus brief from the Supreme Court of Court of Appeals, Kentucky. And we talked about it. We did. So he suggested that I try to get together a group, to develop a group. It would be the people that practice the workers' comp and represent the interests of state workers. And we did. It's called K, easy to remember, Kentuckyans for Economic Revenue. We have approximately 100 members across the state, many in your areas. And it's really important that we understood what our goals were. So we would donate our legal services. The AFL-CIO would file a brief at no cost to the AFL-CIO. And Bill knows this. We believe and feel that it's made a difference in the Supreme Court and the Court of Appeals. And I'd like to tell you that's something in the past that we don't have to worry about it, but Dustin, it's a battle every year, every month. There's going to be cases that are right now that are pending in that respect. So let's talk a little bit about workers' comp. Bill, I want to thank you on behalf of the injured and disabled workers, the group, the K group, for everything you've done. And I hope I can learn how to use this. I do. I want to thank you very much for the efforts that you've made. And I know you're going to hopefully still be around to continue to help with the insight and things we need to do, because it really has been a great working relationship. Now, let's talk about workers' compensation. Workers' compensation, and it's really important, and Bill knows this, I was commissioner a few years ago of the Department of Workers' Claims, and a good friend of mine came to Frankfurt, and I know the IBEW people recognize Donnie Colston, and he was like my deputy commissioner for labor. And Donnie came, and we basically embarked upon the communication education. So great to be able to reach out, talk, and do training sessions. It's been a while since I've been commissioner, but I've still done those training sessions. I know many of you have attended them. I know the value of it. But it's communicating what a person's rights are and what they should expect if they have the misfortune of sustaining a work-related injury. And so these training sessions, with COVID and a few other things that came up, I started talking to Bill, and I said, you know what? Let me see. It would be nice. Let's see if we can put together a link on the AFL-CIO that would explain what rights are, if I'm doing this right. Miles? There you go. We put together some videos. They're on YouTube. And it's in the works right now. I was hoping to basically be able to show you a link and your members could go to this link. But we put together some YouTubes that are about educational information about workers' comp. This was entitled, and this will be for your members to come. And we've set it up, or it's being set up, it's almost done, I believe. Where the member comes to the website, it doesn't take them to my website. It keeps them right there. And you have all these YouTubes. I'm going to show you a couple today. See if you like them, don't like them, but at the same time understand we can make changes. And this has been at no expense to the AFL-CIO. This is what I've put together. And I told Bill, if I go tomorrow, these videos will still last and still be there for people to basically use for education and communication purposes. Let me see if I can get this played.
Hello, I'm Ched Jennings, founder of the Jennings Law Offices in Louisville, Kentucky. Is a caseworker in the room when you meet with your doctor? They are not your friend. They're actually employed by the workers' compensation insurance company. Their goal is to influence your doctor's treatment of your workplace injury. Perhaps they'll try to even get your doctor to return you to work with restrictions sooner than needed. Basically, they're there to save the insurance company money. Under Kentucky law, you have the right to meet with your doctor in private. This gives you the opportunity to get the best care for your injury. You have the right to request the caseworker not to be present during your time with your doctor. If the caseworker refuses, ask him or her to give you a text, email, or letter telling you that they have the right to be there. You'll never get that in writing because it just isn't the law. In fact, as your attorney, the caseworker has to have my permission to have any contact with you. Again, the caseworker is not your friend, even if they act very nice. You don't want to let them influence your doctor. I'm Ched Jennings, and I'm a Kentucky workers' compensation attorney. We can talk more about this during our initial interview. Remember, at the Jennings Law Offices, there's no charge for my initial interview with you.
Now, another important part about Kentucky law is that the injured worker has the right to pick his doctor for treatment, has the right to go to whichever physical therapy he wants to go to, has the right to go to the pharmacy, go to a chiropractor. And this is important because a lot of times, as you know, the company requires the injured worker to go to the company doctors. They're requiring them to try to treat you there. Until these workers know that they have the right to pick their doctors, it's important. So I want to show you this video, and hopefully it does reach the same information.
Hi, I'm Ched Jennings, the Jennings Law Offices. Were you told which doctor to go to for treatment of your work injury? Do you realize those are company doctors? What you didn't know is that you have the right under Kentucky law to pick which doctor treats your work injury. You have the right to pick your own pharmacy. You have the right to treat with a chiropractor. You have the right to choose where you go for physical therapy. Do you want to treat with the company doctors, or would you prefer to get treated by a doctor who's protecting your best interests? Remember, it's your choice. By the way, if your employer insurance company is denying you the right to pick your own doctor for treatment, ask them to put that in writing. You'll never see it. It's not the law of Kentucky. Remember, it's your choice. We can talk more about this during our initial interview. Again, I'm Ched Jennings. Thanks for taking a minute to listen.
Now we'll go back a little bit because I'm going to now lead into our update to let you know what's been happening the last couple of years and some really good things. We still need to push for it and push hard for it. Where did workers' comp law come from? It began back in 1912. By the time it was upheld as being constitutional by the Supreme Court of Kentucky, it was 1916. There are three purposes that were set forth by the legislature back then and the courts: early delivery of disability pay and medical treatment. That's a right, preserved right for injured workers. And then have speedy resolution of compensation claims to to resolve the disputes. And if you look at the history of the Supreme Court opinions over the years, you will see the Supreme Court of Kentucky, when they balance the equities, always refer back to what the purposes and intent of the Kentucky Workers' Compensation Act has been and continues to be. So what happens? What happens when COVID comes? Shuts everybody down. You know what that's like. Shut the buildings down. So what do you do with the workers' comp system? How do you get people their benefits? How do they have hearings? How do they have their depositions? Before, everything was done in person. So the Department of Workers' Claims embraced Zoom. And I'm sure everybody in this room knows about Zoom, or at least has worked with Zoom. We replaced the in-person with Zoom. And it really turned out, it wasn't intended that way, but it turned out to be a better system. Think about this. A better system for injured workers. That's what the purpose and intent of this Workers' Compensation Act has been for. Why? Because the injured workers don't have to necessarily drive. They have on the device. They can be on Wi-Fi, and they can have their hearing. Most of mine have their depositions and hearings from their home. They don't have to bear the expenses to travel distances. So you have the judge in Paducah, and you're in Owensboro. To have a hearing, where are you going to go? Louisville? You're going to go to Lexington? The injured worker has to get there. Now, for the most part, if they return to work, they've been off work, they're worried about their job security. What happens? They have to miss a day of work, or they miss income. I've had workers actually do these from the employer's facilities in a conference room. Now think about this. They only take about an hour, and these are hearings, and they're in the conference room, and it's a win-win for everybody because the injured worker gets his day of work, he gets paid, the employer doesn't have to bring anybody in to replace him or shove the work to another day. So everything's a plus with these Zooms. And those who have pain can't necessarily drive long distances. And what's worse, they have to get their wife or their spouse to take it. And when you think about that, they have to miss work, or they have to pay. Gas prices there, it's coming down. Used to be up to $4 a gallon. They would have to pay somebody to take them to a hearing, several hours out of their day. And so it was very, very tough. This is more efficient for the injured workers. It's better for the injured workers. And what I was going to tell you, it's better for everybody else. If I need to get a hearing today for somebody that's got a problem, can't get an operation, needs to have the judge decide where it's work-related and where not that we should pay benefits, I can get one within 2 weeks. In person, you can't do that because it depends on the hearing locations. Another thing, hey, COVID's not gone. You've got the flu, you've got everything else. Everybody in this room knows somebody that's been sick in the last 30 days. Everybody. And then let me throw you another curve. I've been concerned about the security of the hearing locations. I mean, let's look at these times. These hearing locations don't have any metal detectors. They have nothing. No security whatsoever. It's not like going to the courthouse. It's going to some offices for that. So I've been very concerned. Zoom is the way to go. It's the much, much better system that we've got. And the judges are more efficient as well. Now, I'm going to just give you some stats. And keep in mind, in 2022, the first 3 or 4 months, Zoom was mandatory. Then all of a sudden, they decided to, well, the policy's been if somebody requests Zoom, it's Zoom. And now we're starting to hear that some of the policy is going to try to leave it up to the judges, which bothers me. Some judges and some defense attorneys basically feel that they want the judge to see the claimant. They want to see how they appear, how they slide into their seat or get up from their seat. And I will tell you in response to that, and I mean this with 110%, our judges, our system should award benefits based upon medical records and the testimony of the claimants, not by appearance. Not by appearance. And I want to keep that in mind. It's another reason why that's a flag they've thrown up to try to do more in-person hearings. But I want to combine these two. And let me just statistics for 22 up till November 1st of 23, 77% of the hearings now, 77% of them are being done via Zoom. That's huge, over 2/3. We still have some in person, but we're pushed, and Bill Londrigan has made it very clear to the Department of Workers' Claims that Labor wants the Zoom hearings, and it's by far the best system to have that. So in touching with that, let me go to the next one. This will explain to you just a little bit more.
Hi, I'm Ched Jennings, founder of the Jennings Law Offices. Let's talk about your hearing in front of the workers' compensation judge. We do this with the Zoom video app. It's a lot like FaceTime on an iPhone. This is the opportunity for the judge to hear you. I want the judge to hear you describe how you got hurt, your pain, your limitations, what's happened job-wise, and how the insurance company screwed with your benefits. This is the opportunity for you to testify about your return to work and how well you're doing. It may also cover why you're not able to return to work. As your attorney, I'll prepare you for your hearing. I'll be the one asking you questions. Basically, I'll be with you every step of the way. Some other people will participate in the hearing: the judge, the court reporter, and the attorney representing the insurance company. The advantage of doing the hearing via Zoom is that you can safely do it from your home. This eliminates the frustration and expense of you traveling to a hearing location. We'll talk more about this hearing during our initial interview. Again, I'm Ched Jennings. Thanks for listening.
All right, now, another big program we're doing. And again, this is something over the last couple of years, mediation. There's always been a statute that there should be mediations of workers' comp claims, but there was never a system in place. Larry Roberts, when he was secretary, who used to mediate cases back in the 70s between employers when they had employee disputes, he became secretary. He challenged the Department of Workers' Claims to implement and develop a mediation program. Very, very exciting. They passed a regulation, and I'll tell you what is the big difference. Mediations, the mediator talks to the claimant and talks to the insurance adjuster to resolve the issues. In our cases, there's a lot of moving parts. Have they been terminated? There's bad blood. Their benefits have been denied. Remember, the role of workers' comp, the battlefield in this, it's a game. If the insurance companies don't pay out and the companies don't pay out, they get the key. That's why you see people being battled. They get to know, they get denied benefits. The mediation that brings it together. Judges, when they do a hearing, can only give a claimant weekly benefits. Mediations get held. Mediation permits lump sum benefits. The injured worker gets a lump sum instead of awarded weekly benefits. You also get, if there's medical bills they've been denied, you get that and paid. I mean, think about that. They get paid under the fee schedules, then. And the mediators are all current ALJs. Current ALJs. We've got 17 of them now. Current ALJs. They're not outside mediators. They're provided by the Department of Workers' Claims. And it's important to remember that because I have trouble explaining to my clients that we're going to do a mediation, and I have trouble explaining to them that the insurance company picked the mediator and they're paying for it. That's not good mediation. This mediation system we have right now, it doesn't pass the optics, quite frankly, of fairness. The mediation system we got now, current judges, they're paid for by the state Department of Workers' Claims. They're fair and they're not biased. Whoops. Let's see if I can get this over. Wow, see if I can look the wrong way.
Hi, I'm Ched Jennings, founder of the Jennings Law Offices. Mediation is a popular way to resolve workers' compensation claims in Kentucky. If your claim is decided by an administrative law judge, the judge can only award you weekly benefits. With mediation, an injured worker usually receives a lump sum. With mediation, you can still maintain your rights to future medicals and the right to reopen your case if your condition worsens. There's an additional significant advantage of mediating your Kentucky workers' compensation claim. In mediation, the injured worker and the insurance company reach a settlement which ends the litigation. It often results in a speedier resolution of your claim. Bottom line, you should be able to get your money faster. We can talk more about this option during our initial interview. Again, I'm Ched Jennings. Thanks for listening.
told you about mediations being set. We normally get those done. If it's done, we get the settlement done, the paperwork done, the benefits in place within 30 days. If you go to the hearing route, it's like 60 to 90. So it's much better, much better for mediation. You'll hear about that a little bit more, but I want to show you some of the stat. Whoops, I'm missing one slide. The one before that, Lyles. There it is. Here's the mediation statistics. These are key. Look at this. 77, 78%. That's for the entire department. All the judges do it. The chief ALJ, who developed the regulation, who oversees the other 16 judges, Judge Gott from Bowling Green, those of you from Bowling Green, is his mediation rate is 95%. Think about how great that is. And we had a board chairman, Mike Galloway, who presented this past year, and he said the reason why board opinions are down, he cites, is because of the mediation program. What's wrong with that? Think about it. What's wrong with that picture? But anyway, that's how successful it is. And I normally end my programs, I used to always say on behalf of CAG, a group of our attorneys, that we've always looked upon you all as our friends and a part of our team, and hope that you, the AFL-CIO, will continue to look at us as your friends, as part of your team. But I have one more thing for Bill. Hold on. Doing it live. There it is. Many of you have seen this, and maybe you haven't, but I think it's really important. And Bill, I've got one frame coming in for, hopefully you'll be able to put somewhere in your house or your office, wherever you might be. It's called In the Arena. For those of you, I don't know if you can see it, I'm going to read it. I know this is terrible to read, but I want to read this to you because it really means a lot, and it really means a lot to me, because I think it really represents Bill Londrigan. And it's called In the Arena. It is not the critic who counts, not the man who points out how the strong man stumbled, or where the doer of deeds could have done better. The credit belongs to the man who is actually in the arena, whose face is marred by the dust, sweat, and blood, who strives violently, who errs and comes short again and again, who knows the great enthusiasm, the great devotions, and spends himself in a worthy course, who at the best knows in the end of the triumph of high achievement, and who at worst, if he fails, at least fails while daring greater, so that his place shall never be with those cold and timid souls who know neither victory or defeat. Theodore Roosevelt. It's a long time ago, Theodore Roosevelt provided this. But Bill, thank you very much for everything you've done. And we'll continue to.
So if anybody needs any help with workers' comp, and I know everybody out here, at their workplaces, are going to experience an injury, an accident, and Ched and his group are all over the state. And if anybody needs, you just call us, and we'll put you in touch with these comp attorneys.